Welcome to our webinar on gross negligence manslaughter, medical, drug and food related deaths, where Oliver Quick and I will be discussing the distinctions between unlawful acts and gross negligence. Many of you will know me, of course. I'm Felicity, Gerry, Queen's Counsel, member of Libertas Chambers, and Dr. Oliver Quick, who is with us today, is one of our academic associate members in Chambers. As you know from the advertising for this event, I defended the appeal in Rebelo #1 at least. So I'm going to, after Oliver's given us his lecture, I'll tell you a few stories about that. But just to introduce Oliver, he's the Reader in Law and co-director of the Centre for Health, Law and Society at the University of Bristol. He's written widely about the law and patient safety, with particular expertise on gross negligence manslaughter. His research was heavily cited in the independent review of gross negligence manslaughter and culpable homicide established by the General Medical Council. And the format of our event this evening is Oliver will give us that lecture for about half an hour. Then I'll tell you a few stories from a practitioner's perspective, and then we'll have the opportunity for a Q&A. But if during the session you've got any questions, there is the chat function which is open, so do feel free to enter your questions into the chat. As I've said, the session is being recorded, so for those people who couldn't attend, who registered, they will get an opportunity to watch this later. So without further ado, as they say, I'll hand over to you, Oliver. Thank you so much for joining us. Off you go on gross negligence manslaughter, medical, drug and food related deaths.
Thanks, Felicity, and thanks for hosting, and good evening, everyone. And before I start, I must also thank Gerard for the invite to be an academic member of Chambers, which I was obviously delighted to accept. In fact, my mother is still dining out on this fact. And like a lot of mums, she's kind of prone to proud exaggeration, so there's no doubt telling her friends that her son is now a barrister. As Gerard knows, my success rate as a litigant in person isn't that great, so I don't think I'll ever have a career at the bar. Anyway, I've long been interested in gross negligence manslaughter, especially medical manslaughter cases, having done some research into what I suppose we can call the empirical reality of these cases, particularly around the roles of prosecutors and experts. And finished a recent project where I was able to have access to CPS case files and publish, I think, the most detailed data published to date on medical manslaughter cases. I'll put the link up there if that works of any interest, and be happy to return to this in the discussion later. I think the first thing to say is, of course, these are all sad stories of preventable deaths, tragedies for families who've lost loved ones, but also shattering for the clinicians involved. And of course, I think all negligent manslaughter cases are controversial, given that the very basis for liability is contested and has troubled the appeal courts in recent years. So here's a list of, I think it's my kind of top 11 GNM cases of the last 100 years or so. And most, the ones in bold, involve healthcare professionals, mainly medics. And I think that context, the medical context, has had a significant impact on the shape of this offence, which of course applies in many other different areas. So Winterton is a construction case, not securing a trench on a building site. Kudus is a food safety case, a peanut allergy. And Broughton, a drug-induced homicide case, supplying a Class A drug and failing to adequately assist. I'm glad that Felicity's going to come back to the Rebelo #2 case, #1 and #2, because I think that raises really interesting issues about the interrelationship between constructive and negligent manslaughter. I think the short story is that unease with the basis for liability and potential harshness, particularly to healthcare professionals trying to do good, has prompted a tightening up of this offence category. I think just looking at this slide, the sheer number of appeals in the last 5 years, and quite a few of them successful, is interesting in itself, and perhaps tells us that all is not well in the world of gross negligence manslaughter. It's interesting that the same judge, Sir Brian Levison, has dominated here, presiding over the appeals in Selwyn, Rudling, Bawagaba, Rose and Kudus, and I think Rebelo number 1, Felicity.
Yeah.
And I think it's difficult to deny, perhaps hard to prove, although there are some extracts in the cases that do provide some evidence of this, that sympathy for medical defendants has really shaped the evolution of the common law here. Now, I think the kind of plight of medics subject to this potentially harsh offence has always impacted on this category. So Bateman's an old case involving an obstetrician, but there clearly has been lots of attention in recent years. Here are 2 reviews, one commissioned by the Department of Health, chaired by Professor Sir Norman Williams, and another slightly more substantial review organised by the General Medical Council, largely following the kind of aftermath of the Hadiza Bawagaba case, or cases, I should say. And this is an issue that's really dominated the medical press. It's accounted for at least 2 front covers of the BMJ in the last couple of years. And I think this clearly has had some impact, clearly hasn't gone unnoticed in the kind of development or the framing of this offence. Before we take a look at the law, I think an interesting preliminary question is about why certain tragedies become criminal cases in the first place. And clearly not all will. I won't dwell on the kind of factors I've listed here, but these seem to me, having researched this quite carefully over the last 10, 15 years or so, seem to be the key factors why certain cases end up as criminal cases. I think the role of bad luck at the bottom there is clearly a relevant one. These cases are not new, so I should acknowledge Mr. Ian Barker from the Medical Defence Union, who kindly sent me this when I was studying my PhD a long time ago, which we think, or he thinks, and I've not been able to prove him wrong, is the first known reported case of a health professional being convicted of manslaughter. Don't know if anybody's medieval legal French is any good, but apparently that's the correct translation at the bottom. He was commended to God, not condemned to God, as another translation claimed. Negligent homicide can be traced to the 16th century, and the label gross, or I suppose criminal negligence, emerged in the 19th century. And at this time, judges weren't concerned about separating gross negligence from recklessness, which is very much a product of 20th century legal philosophy. I suppose it raises the first big question for us: is gross negligence an objective or subjective form of fault? Well, in theory, it's supposed to be objective. I guess that's the whole point of negligence liability. But in reality, it's clearly something of a hybrid model, as is often the case with criminal offences. I think we can go as far to say, or I'll try and show, that in practice, proof of recklessness is required. Perhaps required is putting it too strongly, but certainly does tend to feature in cases resulting in convictions, or absence of recklessness seems to be relevant in successful appeals. And this is something that became apparent to me on interviewing prosecutors over 10 years ago now, in asking them to talk through their decision-making process in such cases. I think maybe a discussion point for later on is whether gross negligence should be abolished, whether it is too vague, it is too uncertain, subject to produce inconsistent outcomes, and whether we'd be better off replacing it with reckless manslaughter. I think this is the key question which everybody struggles with. Is criminalising negligence appropriate? And this isn't just a question for legal philosophers, for the Harts and Glanville Williams and Andrew Ashworths of this world, but clearly for prosecutors, experts, judges and juries. Clearly the debate, and it's an enduring debate in legal philosophy, is an interesting one. So Hart famously defended criminal negligence as part of a capacity theory of responsibility, and what he termed culpable inadvertence. Others, such as Glanville Williams, famously had subjectivist misgivings. But when it's been looked at carefully, evaluated by 2 Law Commission reviews, in recent memory, it's been given the stamp of approval, so to speak. But I think it's clear when you look carefully at the cases that the lingering unease about criminal negligence, particularly in cases involving people doing socially vital activity, doesn't seem to inform the evolution not just of the gross negligence element, but the other elements of the offence, including causation. So Adamarco is the House of Lords decision, and I suppose strictly speaking, still the leading authority here, although the 4-stage test that Lord Mackay put forward here has evolved into a 5-stage test, in fact a 6-stage test. I do hope we don't get to 7 or 8, but I suspect we will as this test becomes finessed and more detailed. John Adamarco was a locum anaesthetist who lost his appeal after failing to spot a disconnected oxygen tube during a routine eye operation. And the evidence was that he took about 4.5 minutes. He was carrying out some checks, but perhaps left the most obvious source of the problem till the end, and it took him 4.5 minutes to detect that the tube had become dislodged. His case went all the way to the House of Lords, and he lost. And I think it's probably difficult to deny the description gross negligence to the egregious failures of Adamarco. Now, this test, particularly paragraph D, the gross negligence element, has been widely criticised for its vagueness and its circular nature. In fact, there's a nice little quote from Lord Mackay in the judgment where he, I think, doubts the need to go any further and thinks that any more detail would achieve a spurious precision. I think that's a really interesting quote in view of what's happened subsequently, and also in terms of what's now fairly detailed, perhaps too detailed, CPS guidance in relation to this offence, which is really as chalk and cheese compared with what it replaced. In fact, I had the pleasure of Lord Mackay's company a couple of years back in the House of Lords and detected a distinct displeasure from him at the way the law has evolved since this judgment. Okay, I think the next case that I think should have probably gone further actually was Misra and Srivastava, 2 junior doctors who failed to diagnose and treat toxic shock syndrome in a patient recovering from a routine knee operation. And again, the same arguments that didn't succeed in Adamarco, in other words, that this offence falls foul of legal certainty, it's too vague, they also were unsuccessful here. But I think this attempt, I mean, I thought this at the time, but I think it more strongly now in view of what's happened subsequently. This attempt by the Lord Chief Justice Judge to draw a distinction between certainty in terms of the ingredients of the offence and uncertainty of the decision-making process is really unconvincing. I mean, I think to state the obvious, there must be a connection between the two. And that last line that I put in bold, that's my emphasis. That looked wrong at the time. That looked a bit too simplistic, a bit too confident at the time. And I think history has proven that to be so. Okay, so I guess what's now probably the leading case, or what's finessed the Adamarco test, is the case of Honey Rose. She was an optometrist who failed to conduct a proper eye exam on a young boy who died 4 months later of acute hydrocephalus, secondary to undiagnosed papilledema, so swelling of the optic discs, which would have been obvious had she conducted a proper eye exam. She didn't look into the back of his eye as she should have. She was convicted, but successfully appealed. And as we can see, the 4-stage Adamarco test evolved into a 5-stage test with a new paragraph C. Well, I say new, the reference to risk of death is not new, but the emphasis on it being a serious and obvious risk of death, and that being reasonably foreseeable based on what the defendant knew at the time, is significant. So Adamarco just talks about the risk of death, whereas now, and Rose wasn't the first case to talk in these terms, but it solidifies, and I think significantly narrows the offence. And I guess this is the kind of hybrid model I referred to at the outset, that it's reasonably foreseeable that the breach give rise to a serious and obvious risk of death based on what this defendant knew. Controversially, Honey Rose failed to comply with her statutory responsibility as an optometrist to conduct a proper eye exam, and somewhat, counterintuitively, that seemed to work in her favour. So I think this narrower test is a response. I mean, again, this is supposition on my behalf, but this is a response to the breadth and potential harshness of gross negligence to tighten up the test on reasonable foreseeability of risk of death. It's also interesting that it's been separated from the gross negligence element. If you go back to Adamarco, we'll see that it actually dealt with it the same in paragraph D. Risk of death is bound up with the overall assessment of gross negligence, whereas it's now been separated since the case of Rose. This may be nitpicking, but I noticed that the running order has also changed. So Lord Mackay, and this is something he did say to me actually when I talked to him, felt that causation should come before the gross negligence element, which it does here. But as we now see, that's changed. Okay, and I think it's a moot point whether Rose has changed the common law. You could argue this is just a bit of reformatting and sort of finessing the test. But I think this is a narrowing. I think that's the kind of better view, that this case does narrow the ingredients of the offence, and that convictions are harder, particularly in specialist cases, in complex cases, medical cases. Okay, so this slide just summarizes, I suppose, 100 years of evolution there in that approach to risk of death. So previously, and arguably far too broadly, in Bateman, disregarding to the life and safety of others, Adamarco, the risk of death, and then cases starting from Misra, leading up to Rose and Kudus, that the risk of death was serious and obvious to this defendant. That begs the question, what is meant by serious and obvious, and why both are needed? I can imagine jurors might think that obvious risks of death are serious, and serious risks should be obvious. There's been little clarification on this beyond the following, that serious qualifies the nature of the risk of death as something much more than minimal or remote. This reminds me of the plumber who recently detected a huge gas leak at my mum's property and admitted that it could have been very fatal, which I thought was a lovely way of describing it. And an obvious risk is one that is present, clear, and unambiguous, that it's apparent at the time based on the information known to this defendant. So the risk wasn't obvious to Honey Rose because she hadn't conducted a proper eye exam, but clearly would have been to the reasonably competent optometrist. Okay, Kudus is a food safety case. Kudus was a restaurant owner and chef preparing a meal which unfortunately did contain peanut proteins and was supplied to a girl who identified her peanut allergy on the takeaway order. I think she had a mild, hitherto at that point, until that point, thought she had a mild allergy to peanuts. Kudus was convicted, but his appeal was successful, largely on the basis, I know I'm perhaps oversimplifying the judgment, but there was no evidence that Kudus saw this information. He didn't see the Just Eat receipt or the takeaway information, which made reference to the allergy. And that seemed to be the crucial evidence in allowing his appeal. And I think it's a good example why this offence invariably looks more like reckless manslaughter than it does gross negligence, because you could argue that, as with Honey Rose, a non-negligent restaurateur would check what was on the takeaway order. Now, this leads to a kind of eye-catching quote that Carl Laird, who pens a lot of the case notes for the Criminal Law Review, makes the point that does this create perverse incentives? So, we can doubt whether criminal law has a deterrent effect, but Carl seems to be suggesting that perhaps this approach deters safe practices. Well, we very much hope not, but you can see the logic of the point that Carl is making there. So in both Rose and Kudus, the Court of Appeal concludes that neither defendant knew about the circumstances which made the risk of death serious and obvious, even though they should have known. The fact that they didn't saves them. I think standing back from it, I mentioned the role of luck earlier on as in terms of factors why cases become criminal cases and what happens to them when they journey through the justice system. I think the role of luck and perceptions about bad luck are in play here, perhaps unstated, but are probably in play. So Rose and Kudus could probably be considered unlucky. Both deaths were preventable, but nevertheless were unlikely given the overall factual scenario. So where has the objective notion of gross negligence gone here? Is recklessness being revived? Well, arguably, it never went away. So I think these extracts from Adamarco and Misra are quite telling. That it's okay for trial judges to make reference to recklessness in explaining to juries what gross negligence means. And as I said, Rose and Kudus are, I think, good recent examples of this, albeit that in that case, it's in reference to the risk of death rather than the gross negligence factor. In fact, it's kind of interesting that the recent cases have really moved away from the gross negligence factor and have been much more about the risk of death and the causation ingredients. Now, I think, one argument is to say, well, why don't we just get rid of gross negligence and prosecute such cases as reckless manslaughter? I'm an academic, so I suppose I can say academic things like that. What would that mean? Well, arguably weaker cases on the cusp, wouldn't be prosecuted in the first place, and perhaps there'd be less scope for appeals if defendants were convicted on the basis of reckless manslaughter. I guess that's one for discussion afterwards. Okay, let's turn to causation. And I think, as we often tell law students, causation is probably one of the most interesting areas on a law degree. And I think, exactly what does establishing causation to the criminal standard mean? Well, simply put, being sure that the defendant's conduct made a significant contribution to the outcome. But as we know, causation has always been complex, somewhat cloudy, and arguably has never been applied uniformly. And that it is, perhaps the golden rule is that it's contingent on the context. So perhaps it's unsurprising that we find inconsistencies, contradictions, when we look carefully at different cases. Now, I think these three cases say really interesting things about causation. So the Sellu case, David Sellu was a general surgeon who was too slow to operate on a man with a perforated bowel. It took far too long, and by the time he did, it was too late. As you probably know, Mr. Sellu served, I think, 15 months in prison. And his appeal has really set the scene, I think, for the appeals that followed. And the judgment there has interesting things to say about the temporal relationship between the different elements in this offence. So what if there's negligence before and after the critical moment from a causation perspective? The Bauer-Garber case is really interesting in terms of this again was a case where a pediatrician, Hadiza Bauer-Garber, was too slow to diagnose sepsis in a young boy. And interestingly, in the evidence here, there was a question mark about an intervening act. The prescription medication that the young boy was taking, that Dr. Bauer-Garber had rightly concluded he should not take whilst he was in hospital, given his condition, but unfortunately didn't write that up on the notes. So when the young boy's mother said to the nurse, shouldn't he take his enalapril for his genetic heart condition, sadly, there was nothing on the notes. So he was given his medication. He died very soon afterwards. But the case I'll spend a bit of time on, because I think it raises a more kind of general point of interest, is about, well, what level of certainty is required for establishing causation to the criminal standard. And this is the case of Broughton, involving the death of a 24-year-old woman, Luella Fletcher Mitchie, who died at a music festival, having been given and taking a bumped up dose of 2CP, a Class A drug supplied by her boyfriend, the appellant. And the case against Broughton was that he was grossly negligent by failing to obtain assistance over a period of a number of hours, which caused her death. His conviction was quashed on the basis that the case should have been withdrawn from the jury, as the evidence, even at its strongest, could not establish causation to the criminal standard. I think there were 4 experts in this case, but only one gave evidence on causation, and he described the chances of survival with medical care at 90%, but that survival could not be guaranteed. Well, that's kind of summary of the evidence on causation. Now, I think it's a really interesting case, and I think potentially quite a significant one, particularly when we work back to look at some of the other cases that I've referenced. And I just pick out this quote that I'm just not sure whether these 2 sentences are wholly compatible with each other. And I guess another good point for discussion. I'm very interested in people's comments here. So the first sentence, the Crown must prove beyond reasonable doubt that gross negligence was a substantial cause of death. Fine, uncontroversial. But the second sentence, to my mind, that's not the same as saying that the Crown has to prove the deceased would have lived. Surely this places the bar too high. Why does survival have to be guaranteed? Beyond reasonable doubt cannot mean 100%, can it? And I think it's really odd. Well, to me, it seems odd in this case that so much reliance is placed on an 1882 case called Morby. I must admit, I'd never heard of, I'm ashamed to say, I'd never heard of until I read, and in fact, it was cited in Celu. That was the only other case where it's been cited in, what, 134 years. And I'm not convinced that a case where the lead judgment amounts to 17 lines, and which wasn't cited for 134 years, is really the best case to rely upon. Plenty of other more recent cases, more significant cases, such as Stone and Dobinson, which it's kind of perhaps surprising those cases weren't cited in argument. I think if you apply the Broughton approach to the medical cases, especially Misra, the toxic shock case, and Bauer-Garber, the sepsis case, then the lingering doubts about causation in those cases, I think particularly Bauer-Garber, become even more apparent. So in the case of Misra, the expert described, and I quote, a very high chance of survival, and believed on a balance of probability that the patient would have survived with antibiotic care. In Celu, the expert talked about a significant chance of saving life. And interestingly, Celu's appeal was not successful on the grounds of causation. And the Bauer-Garber case, the risk of death on admission for the young boy was quantified to, before Bauer-Garber began her care of the boy, the risk of death was quantified as being between 4 to 20%. And the jury were directed that significant meant more than trivial or minimal, and was left to their good sense. And I can't help wondering what these medical defendants, who admittedly delivered poor care, make of the outcome in a case such as Broughton. So here's another quote which essentially says the same thing, but again, to my mind, the last line, that she would have lived, suggests a certainty which is not possible or necessary. And one wonders whether that could be finessed with, almost certainly have lived. I suspect the unstated view in a case like this, and I can't put it any stronger than that, was that the cause of death was ingesting the drugs and not the failure to obtain assistance. I suppose there's some logic in that what really caused her death, it was taking the drugs more than not being assisted. However, when we compare a case such as Broughton with a case such as Evans, the 2009 case, a gross negligence case, then that's an otherwise similar scenario, save for the fact that that case involved heroin, and this case involved a drug that was generally regarded as being less lethal. I think that there's more to this, though. I think it's likely to reflect a broader unease with manslaughter by omitting to seek assistance. So some of the old cases that first-year criminal law students look at, the sort of Good Samaritan cases, the failure to assist cases, I think that old-fashioned approach seems to be reflected in the approach in this case. Now, I suppose you could take the view that omissions don't start causal processes, and they only allow other causal processes to unfold. But of course, in this case, in the Broughton case, it's the defendant that supplies the bumped up dose of drugs. So that isn't strictly speaking true. Okay, I think my time is nearing to an end, so I'll just go.
Well, no, keep going and finish, because I can canter. Okay.
So I'll just sort of try and draw some of these threads together and identify some discussion points before handing back to Felicity. For what it's worth, I've long argued that recklessness would be preferable to gross negligence. I accept that's probably a minority view and is open to the remark, well, what difference would it make? Or what difference would it make in practice if cases were prosecuted on the basis of recklessness as opposed to gross negligence? Well, I think that, in theory, it should raise the bar of proof and make it slightly harder to get home, and that cases on the cusp, cases which aren't that strong, probably wouldn't, or less likely that they'd be prosecuted in the first place. I'd be interested in people's thoughts on the CPS guidance that was published, I've got it here in front of me, on the 14th of March 2019, which is clearly partly a response to the interest around the medical cases and the reviews that I cited at the beginning. And I'd be interested in people's comments on whether that's helpful or not. I mean, at the end of the guidance, there are some factors identified that speak to grossness, and one wonders whether they will be cited in argument or fleshed out in due course. Some have argued for a specific offence. I'm certainly not convinced by that. I think that's a bad idea. Where does that end if you start creating specific offences, namely offences covering deaths caused by healthcare practice? In terms of causation, I was rereading the textbooks in preparation for this. I thought I should do a bit of legal research, and there's a nice quote from Glanville Williams's textbook on criminal law in 1983, where he says, in his typical confident fashion, "Hitherto, the judges have made little progress in establishing the principles of causation." I think that's actually aged quite well. I think that largely rings true, doesn't it? And there's an interesting discussion there whether that's problematic or not. Causation is perhaps at bottom about moral responsibility, and so maybe we can live with different variants of different types of causation tests for different contexts. But on the face of it, I think that is problematic. I think it's really hard to say, and I think it's highly likely that all the significant actors here, lawyers, experts, judges, and juries, that they're not on the same page when it comes to understanding what causation means, particularly in complicated factual scenarios, particularly in medical cases. I think a case such as Bauer-Garber, where there's a lot going on, is very complex when it comes to causation. A case such as Broughton, I would say less so. Obviously, much is left to the common sense of the jury, yet that can be very quickly undone and perhaps undermined by unpicking expert evidence on appeal, such as the case of Broughton. The jury made a judgment that they felt content that his failure to assist was causative of the death, but the appeal court felt able to distrust that, essentially, or distrust that the evidence supported that. I think, and again, I've long thought, and can speak to this in the discussion if it helps, that there's a real problem around managing experts and their evidence in this context. And it's very striking and perhaps unsurprising that experts give opinions in a range of cases, mainly civil, but can't help slipping into the language of civil law when giving opinions in criminal cases, and that does raise lots of problems. Okay, I'll stop there and hand back to Felicity. But yeah, thank you for listening, and very happy to take any questions and respond in the discussion.
Thank you, Oliver. I've put a note in the chat if anyone wants to put some questions in the chat or save them to the end. And as I say, I can canter through. Your last comment, I certainly agree with Glanville Williams. It's something that I've banged on about for quite a long time, that we sort of had 25 years of Igor Judge as the Lord Chief Justice and Tony Hughes as the Vice President, and this language of ample evidence and fact specific that did lose sight of legal principles. So I'm quite interested that he was saying that in the 80s, because I certainly found it during the course of my career, and bringing Rebelo to the Court of Appeal was a really interesting experience for me that I'll tell us about when I get to that story. I thought it would be helpful for me to just give a practitioner's perspective on manslaughter. We can't cover everything, but we did say we would look at distinctions between unlawful act manslaughter and gross negligence manslaughter. But I think it's worth a reminder of where manslaughter pops up for us as practitioners. So in complicity cases that used to be called joint enterprise, we often have this language of, well, it's no intent manslaughter, which is a nonsense and isn't really real. And I have found that there have been some very poor legal directions on manslaughter as an alternative to murder. And you have to work quite hard to get the judges to engage in the elements of manslaughter as an alternative to murder on what you might call a joint enterprise indictment. And at the moment, we seem to be having a discussion around a shared intention to cause some harm, which is, of course, not no intent manslaughter. It's a killing with intention, but for some harm rather than serious harm. So that seems to be where we're getting into in joint enterprise cases. We then have killings where there is intent for murder, but a partial defence applies. So loss of control, diminished responsibility, or killing pursuant to a suicide pact. Then we have unlawful act manslaughter. So we're thinking here about the accused deliberately doing an unlawful and what is labelled a dangerous act. But of course, the definition of that is putting someone at risk of some harm rather than really serious harm. So that the dangerousness aspect is an objective test, but an objective test in relation to some harm. So it's not, did the accused recognise that that it was dangerous, but would all sober and reasonable people realise its danger? And that is the danger of some harm, which actually isn't the ordinary meaning of dangerousness, in my opinion. So then we have, of course, gross negligence manslaughter with that test that Oliver's set out for us. And of course, we now have corporate manslaughter created by Section 1 of the Act. So some criteria here that we really have to think about that are different in different types of homicide that require us to really think about the legal elements to prove these differing types of offences, and I think really push us to think about what are the legal principles in these particular situations. Where are we on subjectiveness, objectiveness, and particularly on causation? And I start my stories in 1993 when I was on a mini pupillage with Stephen Coward, Queen's Counsel, the late Stephen Coward, Queen's Counsel, who most people remember for his defending Ian Huntley in the Soham killings. But in fact, he pops up in nearly all the very useful complicity cases that are used in Jogi. He certainly recognised the injustice of parasitic accessorial liability, but he also led the appeal in a case called Prentice, Suleiman and Prentice, in fact, at the time. And I was a mini pupil. I went for a week to follow him about. I think I was at bar school at the time, and I was fortunate enough to follow him to the Court of Appeal. And the story in that case was that two separate cases were joined for their lordships to hear together, and two doctors had in effect injected people in the wrong place. So short version from one of the cases was a syringe has IV written on it for intravenous in your arm, or IT written on it for intrathecal in your back, a lumbar puncture. And each doctor had injected the person in the wrong place and putting an intravenous injection in the spine, and those people had died. And each doctor had taken the syringe from a nurse, really without reading the label. And I learned two things. The first was when the judges opened their mouths, and at a time when we'd sort of lost gross negligence manslaughter, and we were in that state that Oliver's just talked to us about, of trying to prove recklessness rather than gross negligence. And their lordship said, well, Mr. Cowd, if we say that the jury should have been directed on gross negligence manslaughter, what do you say the test should be? And he opened his mouth and said it, and that later became the test in Adamarco. But because Solomon and Prentice were acquitted in the Court of Appeal, his words were used by others because he didn't need to go any further. And the second thing was the practical approaches of the Court of Appeal that I learned, which was, so first of all, you learn that laws are not made by judges, they're made by the advocates who appear before them and come up with the arguments before they give them to the judges. And secondly, the practical reality. So at the end of the hearing, the judges said, well, look, we're going to quash these convictions, but we're not going to send it back for a retrial, but let this be a message to the medical profession, read the label. So that, it seems to me, was actually the seminal case before Adamarco came along, was that it was telling medical professionals who are generally trying to do their job properly, who make mistakes like not reading a label, but the result in death is going to lead to potential criminalisation. And obviously now we have the Corporate Manslaughter Act for corporations and organisations for serious management failures. But there we can start to see in 1993 these warnings to the medical profession that the law is going to expand itself to those people who are regularly dealing in death. The next case that's interesting to me, I wasn't in, but in 2007 was Kennedy, and it's relevant to think about Kennedy before we get to Rebelo #1 that I was in. But Kennedy was the case where it was said, well, hang on a minute, in the case of it's an administration case involving the administration of drugs, and the question the court certified was when it is appropriate to find someone guilty of manslaughter where that person has been involved in the supply of Class A controlled drug, which is then freely and voluntarily self-administered by the person to whom it was supplied, and the administration of the drug then causes his death. So when is it appropriate to find someone guilty? In virtually the similar circumstances, same circumstances as in Broughton in 2020. And my take on all of this is that we give people the autonomy and agency to harm themselves. So if someone chooses to take drugs or chooses to take a poisonous diet pill, they have the autonomy to make mistakes, to self-harm and to suicide. And that's the thread that I see in these cases, that we're not, particularly when the victim is a woman, that we're not constantly victimizing people. We're giving people agency to do their own bad things to themselves. So that's the thread that I see. But what was interesting in Kennedy was that the answer to the certified question was, in the case of a fully informed and responsible adult, never. But the question then is, well, when is it in the case of someone who is not fully informed and responsible, which was the question that we had to try and answer in Rebelo #1. And my next area of interest, although I wasn't in the case of Kennedy, that became a really interesting area for me that I sort of kept an eye on for years. But you have to get the brief before you can be involved in the case, and it took me quite a while. But in the meantime, I did some work with the late Gerry at the Open University when the corporate manslaughter and corporate homicide legislation came into force in 2000. I think it was beginning of 2008, but it was a 2007 piece of legislation. And there's some really interesting publications that Gerry has left out there if you want to Google them. Some of the work that we did around training in the context of systemic failures. And I do wonder, as Oliver says, you know, where are we with criminalisation? Is it more important to raise the bar for individuals like medical professionals who are working in a constant world of potential death, so that recklessness is the issue for individuals, now that we have gross negligence for systemic failures by corporations and organisations? So I think it's worth thinking about how the law is developing legislatively as well as in the decisions made by the courts through case law. And we can look at other cases. Evans is quite an interesting one where someone has the questions of duty of care of a mother in relation to her sister. So these relationships where people are looking after family members who self-inject or self-harm or have addiction of some sort, where family members decide not to seek medical assistance, in that case for fear of getting into trouble. And that was, again, there was a thread in there that we can see in Broughton. At what point are you responsible for the death as a question of causation if you fail to get medical attention from someone who needs it as a result of their own addiction? Had the defendant created a dangerous situation and failed to take action to reduce the risk by summoning medical assistance. And that was quite interesting in the court deciding that it was for the judge to decide whether to leave a duty of care to the jury at all. And there's a decent quote from the Lord Chief Justice that the duty necessary to found gross negligence manslaughter is plainly not confined to cases of a familial or professional relationship between the defendant and the deceased. In our judgment, consistently with Adamarco and the link between civil and criminal liability for negligence, for the purposes of gross negligence manslaughter, when a person has created or contributed to the creation of a state of affairs which he knows or ought reasonably to know has become life-threatening, a consequent duty on him to act by taking reasonable steps to save the other's life will normally arise. And that was really the question that was answered differently in the Court of Appeal from how it had been answered by the jury in the court below. So I think Oliver's right, it's sort of still out there. There are points at which you are responsible, but we've got this test now, would they have died anyway, which is really unseemly and uncomfortable, and I'm not sure it really ought to be a legal test. The real question is whether or not that duty of care has arisen. And in the midst of all of this, I was instructed to prosecute a case called Shepard at Lincoln Crown Court, which involved an allegation of failing to feed and water very, very old people in a care home by nurses. And again, I think what Oliver tells us is really interesting around the evidence available. What is the evidence of allegations of manslaughter or failings in duties of care of caring or medical professionals? Because here, substantially the evidence related to the food and water charts relating to these patients. And there were some significant gaps that were originally filled by expert evidence that this was this was direct failure by the nurses and not a systemic failure by the care home. So it was the nurses that were being prosecuted, and their real argument was probably this was systemic failure by the care home because we were so busy. We did feed and water these people, but we didn't write it down because we were so busy and understaffed. But in fact, in the end, the experts did exactly what Oliver warned us about, was that they really applied a civil standard in a criminal case, and there came a point where that prosecution was unsustainable and we offered no evidence. But I thought it was a really interesting one at that tension between individual responsibility and systemic responsibility. And can you put a pin between the two? And what happens if the system isn't the subject of a corporate prosecution, the individuals are, and then that prosecution fails? There is then a lacuna in the way in which we're dealing with these very difficult cases. And I'm not sure that's cured by having computer-generated records as to when people are fed, watered, and given their medication. So I think that sort of question is still out there. Which brings me then as quickly as I can, with about 8 minutes to spare, to the case of Rebelo number 1, in which I was instructed to defend a man accused of what was originally a single count that alleged both unlawful act and gross negligence manslaughter, and the particulars alleged both of those things. And after a lot of legal argument, largely on my birthday, it was decided that had to be split into 2. Now, the story is that the defendant had bought a powdered chemical called dinitrophenol in great big tubs from China, and he'd put them into little capsules and sold it on the internet. And it was a very popular chemical amongst bodybuilders who use it to effectively melt the fat in their bodies just before they give their demonstrations of their muscular bodies, because it makes them look more veiny. And the research there was some research carried out in the 30s about whether or not this substance was dangerous, but lots of people had terrible side effects, so that research was stopped. And then there was a bit more of use of it in America by some diet quacks, I suppose, in the 80s, and it was banned in America but not banned in the UK. So but with some warnings around that particular chemical. So anyway, he imported it, he made the capsules, he sold it on the internet, and she the deceased woman had an eating disorder, and she ordered it from the internet. She knew exactly what it was, she knew exactly what she wanted, and she knew exactly what she was taking. We had her internet search history and all her communications. So we knew that she had when she'd ingested these tablets and how many she'd taken, and frankly, why. So on the question of unlawful act and dangerousness, it was really interesting because the unlawful act was alleged as a regulatory offence. He was selling this unlicensed product. So the prosecution case was, well, that's enough. It's an unlawful act, it's an unlicensed product, it's a regulatory offence, and therefore it's unlawful act manslaughter. And no amount of arguing from me in the lower court that actually it has to be an unlawful act that causes death would work. And the judge left both unlawful act manslaughter and gross negligence manslaughter to the jury, and they convicted on both. And my argument very quickly in the Court of Appeal was Bill Davis, who's now taken over Leverson's spot in relation to manslaughter, as far as I can tell, because he was the judge, Lord Justice in Rebelo number 2, very early in the hearing said, well, why is this an unlawful act? To which I said, well, exactly. Why are you arguing this, Miss Gerry? Well, I've got to deal with what's coming. And my view was, you can post it and leave it on the table and it's not dangerous. It will sit there forever. It's not going to harm anyone. It's different from those cases where someone chucks concrete off a bridge or posts someone a hand grenade or something that is of itself dangerous. So it has to be an unlawful act, dangerous act that is causally connected. And in this case, the act of causation was her picking them up and ingesting them. Now, what was interesting on causation, of course, was whether or not it was her autonomous act or his supply that was the cause of death, and whether or not her act, whether or not there was a chain of causation from him, or the causation stems from her. And I'm not sure I like to call that a break in the chain of causation, but I suppose you could call it an intervening act in the chain of supply. And I thought that was the really interesting point, because in the trial, the prosecution called an expert to say that she lacked capacity, and they applied the criteria in the Mental Capacity Act. And no amount of arguing by me would be accepted that capacity is not the test. And you certainly can't go around judging vulnerability as set out in Kennedy, for example, on the basis that every young vulnerable person has no autonomy. And this idea that we're going to judge someone's lack of capacity or otherwise on medical records that may or may not have been filled in properly, it struck me was really contrary to the law on causation that requires free, informed and deliberate acts. So I used Lord Kerr's decision in the Irish abortion case on what women's autonomy really means. And I found myself sort of defending her as well as my client in front of the jury. It didn't work. They convicted, as I've told you. And then obviously I argued the same point in the Court of Appeal, which was accepted, that the question for a jury is whether or not it's the autonomous act of the individual, which was defined from Hart and Honoré's work on what a free, informed and deliberate act by her. And the jury at the retrial decided that she was not free, largely as a result of evidence from a new defence expert that was called by the new defence team that Mr. Rebelo promptly sacked. So they're both really interesting to read, I think, as well for seeing Lord Justice Davis come into Levison's spot and to see how they explain Rebelo number one. But we are left with these factual words for juries. So what does free, informed and deliberate actually mean? Now that we've got that, that's how we decide whether the causation flows from him or from the autonomous acts of the person in the middle, that people have a right to self-harm, make mistakes and even suicide. But what we're going to do is judge it on a question of autonomy. Well, what does freedom mean there? What does it being informed mean there? And what criteria are juries going to apply? So I think there is some more work to be done. And they are both very interesting cases to consider. And of course, in between Rebelo and number one and number two was the case of Broughton, which goes back to this idea of at what point do you have a duty of care for someone who chooses to take drugs, and what is the test around that choice, and at what point do you assume that duty of care once someone is screaming in agony? I have no doubt the jury were horrified by the telephone call content that related to poor Luella as she was dying, and morally shocking that the paramedics were not called. And the question that's really interesting here, I still find, is the thread of, look, we allow people to make these bad choices because people are autonomous. And it gets really interesting when you have such extreme lack of morality not to pick the phone up, regardless of the drug taking, and call the emergency services. So I think that's the really interesting thread that I can find that perhaps draw those together, which is sort of easier to understand, but still doesn't solve the problem of certainty of the law on causation. And again, the other thing that I find interesting is there is legislation in America that allows for liability for homicide where the supply of drugs leads to a fatal overdose. But there is now already debate about whether such laws are good policy, because are they needed to punish and deter dealers? And I can certainly tell you that the prosecution stood up in the Court of Appeal in the case of Rebelo number one and said, well, if these people supply drugs, they should go to prison for anyone who dies. And my view is that's exactly the problem, that we do autonomously. We can't make those decisions that every supply of drugs leads to a prison sentence if somebody dies, that we do very much make choices to take drugs ourselves, and we ought to be responsible for our own actions. And I think that's where it's really interesting. The opponents argue that those laws in America are not a deterrent and in fact discourage people from calling 911. So what's really interesting is that the fear of drug prosecution is affecting the reasons for calling the emergency services. So I think there's some work to be done around drug prosecutions as well in this context. So we can get a handle on when things are really gross. Is it really gross, or is it just what happens on a daily basis in society, however morally unacceptable it may be? And how do we differentiate between these ideas of grossness and dangerousness in the context of the supply of food or drugs, or the behaviour of medics who are working in a field that does involve a lot of death? So no real answers, but some really good stories that I think, I hope that you all find interesting. I think we've got some questions in the chat now, so we can go over to our Q&A. And I'm really going to finish there because I just wanted to tell some stories and talk about what I thought about those cases from a practitioner's perspective, and how many arguments you have to mount in these cases on every single element to try and force the courts to deal with it as a matter of legal principle rather than just fact or fact specific. You can start to see how these cases cannot turn on what's fact specific, because those are moral judgments and we need to identify what the legal principle is. I will say that Oliver and I are going to write this up as an article as well afterwards for Libertas Lens. So if we don't answer questions tonight, or you think of a question afterwards, then hopefully we'll answer that in the article in the Libertas Lens afterwards. And hopefully Sarah, who's with us, we'll post a link to how to subscribe to the Libertas Lens into the chat for you. Just looking at what is in the chat box, apart from we had some technical issues as we go along. Oliver said, I'll read out what you've said. It seems somewhat bizarre in Rebelo that the conclusion that the supply of drug is not dangerous for the purposes of unlawful manslaughter, but at the same time conclude that the same act exposes the victim to a serious and obvious risk of death for gross negligence. That just can't follow, can it? Surely an obvious and serious risk of death is dangerous. And there is a huge inconsistency there. In reckless manslaughter, it's recklessness, unlawful act manslaughter, recklessness of some harm. Gross negligence manslaughter has always been thought of as perhaps the lesser offence because it's based on negligence rather than recklessness. Now has this test of obvious and serious risk of death. So the only way I can justify it is to say, well, because recklessness is applying your mind to something and going on to take that risk, then you're being really risky about any sort of harm. And we've decided that that makes you criminally responsible, even if the consequence of what you do is not that bad, I suppose. But obviously in this context, somebody dies, so the consequence is pretty terrible. But in gross negligence manslaughter, they're saying, well, you haven't really applied your mind to it in the same way, but we're going to criminalise it because the context in which you're doing it is really bad. So these are the two ways in which we say that you're criminals. You're not just professionals making mistakes or individuals overriding someone's autonomy. So I think that's where we're getting to, but I certainly don't think the courts have said that. And I think it is wrapped up with, at what point do we say this is your fault, causation, rather than the fault of the person who is either in your care or has chosen to do something that is otherwise unlawful. But I don't know where you get to it, Oliver. I think it's worth handing back to you on that comment.
I was just thinking about where can we trace this back to, and I suspect it's Kennedy number 2, isn't it? Because until that point, a case such as Rubello, because Rubello is not really a negligence case, is it? To be truthful, it's a unlawful act case. But obviously...
No, it wasn't. I won on that one. Not anymore.
It doesn't really fit the bill for a...
No, or of either, actually. It didn't fit the bill of either. That was actually my argument, that this is neither.
But obviously, as a result of Kennedy number 2, I mean, Evans was, I think, the first drug case to be put on a gross negligence front, wasn't it?
Yeah, I think so.
What we're seeing is it's the wrong form of negligence. Therefore, the rules are being kind of tailored to fit around a scenario that the actual category isn't designed to cater for. That's my take on it.
Yeah, I think it's all wrapped up. I think we've got a question from Lauren Towers about what about her mental health? Surely that impacts the case. And the answer to that is, well, yes, because the Court of Appeal said the test for autonomy is you have to be free, informed and deliberate. And if someone is vulnerable in the Kennedy sense, they're not free. And although my client knew nothing about her mental health or her eating disorder, I mean, it's really sad and shocking. She was a brilliant young woman. He knew nothing about it. So in Kennedy, it's a case where at least the person you're supplying to, has a drug problem. Whereas in Rebelo, the person you're just supplying to everybody who's choosing to take this stuff. That's their problem, not mine, is the core issue. So of course, the fact that someone has some form of mental health problem is relevant to that question of autonomy. Are they free? She in particular was informed and deliberate, but the question was she free in what she was doing? Or you could argue, was she not deliberate? Was it involuntary? There wasn't enough evidence to say that she was involuntary. So what the court tried to do was try to express a place where you could sort of slot in vulnerability without actually saying that, but just leaving it open as a fact for the jury to decide, is she free, informed and deliberate? So on this question of what does free mean, that was exactly what was raised in Rebelo number 2. And the court just says, well, of course she wasn't. And there was ample evidence that she wasn't, without actually answering the question. So I think there is some more work to be done on how does vulnerability fit? Does it fit in free or does it fit in deliberate? And why, the fact that someone's vulnerable, why does that make them lose their autonomy? You can be very, very vulnerable, but you still choose to do something terrible to yourself. You've got, in my opinion, you've got the right to. At what point is it someone else's fault that something terrible has happened to you that you have the choice of doing? And it does come down to, how do you find criminal responsibility? And I think in manslaughter, we're trying to find it in the context of causation, rather than simply say, well, it's a regulatory offence. We're not going to prosecute. We're not actually going to try and make it into a crime. We're going to capture it as a regulatory offence. We've gone down this path of criminalising certain types of conduct towards certain types of people without actually thinking through the legal principle. I think that's where I get to on it. I don't know about you, Oliver. Lauren is saying the concepts are so flexible at times. I think she's spot on.
Yeah, and that, if you look at the cases, there are quotes that acknowledge that in judgments, aren't there? I think Evans is a good example.
Yeah.
Kennedy, there are some nice quotes in there that acknowledge that, particularly with causation, there is transparency that the rules are being applied differently in different contexts. And I suppose it's an interesting question whether we think that's appropriate or not. But yeah, I don't think that's being hidden, is it? I don't think that there's no denial of the fact that causation is being tailored to different circumstances. But I mean, you think about the case of Evans, okay, compare that case with the Broughton case. Evans was heroin. I mean, they're both class A drugs, aren't they? But heroin clearly more dangerous than the 2CP drug in Broughton. But I think at trial at Evans, the trial judge refused any argument that there wasn't, the causation wasn't established. And you just wonder whether you could easily unpick it, couldn't you, and apply the same sort of analysis in Broughton and ask the question, well, had they called the ambulance, would she definitely have lived? I think that's putting it to, that test in Broughton, I don't know what other people think, but to me that seems to be setting the bar too high?
Yeah, as I say, I think my view is there's some work to be done on where, not just where the bar is to be set, but how do we know where that bar is? You know, how can we be certain, particularly for medical professionals? I appreciate them that, you know, if it was your daughter, you'd string him up, you know, the moral questions when it's family, or whether it's the boyfriend, or all of those moral questions that come out of these very personal stories that we see in these types of cases. But particularly when it's a medical professional, if you're a patient, you want to know that the doctor knows where the line is. Never mind, the medical professional needs to know where the line is. And I think that's where it gets problematic. And obviously the legislative solutions have not been solutions at all in America. So maybe we can say, well, our courts at least have stepped carefully before Sullivan and Prentice in one way, and after Sullivan and Prentice in another way. And I think we will go round and round, but whether we'll ever actually identify what the answer is, I don't know. I did actually, when I stood up at the end of Rebelo #1, tell their lordships that I was 25 years earlier, I'd been in the same court as a mini pupil and at the back of court, and it was quite nice to be at the front. So I suppose we haven't solved it in 25 years, but hopefully the next generation of lawyers, those of you listening in, can help us solve it in the future. But I think it's still worth watching this space. Causation is long forgotten, been remembered, and now how does it work? All right, so I think that's everything in the chat. I think, oh, Adrian's just come in, last minute driving matter that we have studiously avoided. Have a look at Hughes. I think Hughes is really interesting on causation in driving. That was the case where someone was prosecuted for death by no insurance, and the Supreme Court had to think about whose fault it was, where the person who died was the person at fault in terms of the driving. And the UK Supreme Court said, well, look, we're going to import some fault into the word driving that's in the legislation. But they actually have a really good conversation in the UK Supreme Court about causation and different ways of conceptualizing causation. So it's a great question, Adrian, at the end, but I'm not going to get distracted by traffic. So I'd ask you to have a look at Hughes, and we'll set up a driving webinar sometime later on in the year to try and answer that question. Can I end with this, with a big thank you to Dr. Oliver Quick for joining us today and giving us that lecture in his spare time, really, but in his time as our academic associate, which has been fantastic. I'm really proud of these webinars that bring together academics and practitioners. I've really been so grateful for the academics that I've worked with on cases who've spent, as Oliver's told us, 15, 20 years really honing in on the collection of cases that are relevant to the issues that you might have come up in a case, and you think, goodness me, I haven't looked at causation for 20 years because I haven't had a case in which it's arisen. There are academics out there who are real experts in this area, and we're very lucky to be able to draw on Oliver's expertise in chambers and have him here today. So Lauren tells us she's a normal person who likes to learn. Well, I think we'll end on that. We're lawyers, so never normal, but we also like to learn, and it's been wonderful to have you here. Thank you for coming, Lauren. And thank you to everyone else for attending. As I say, there will be a follow-up article in Libertas Lens, and it will switch off very quickly when we switch off. So I'll say goodbye, and thank you again, Oliver.
Felicity, thank you, everybody. Nice to meet you virtually, and yeah, look forward to the next one.
Thank you. Take care. Bye-bye.